All right, welcome back to a Colorado exam prep. And today we're going to talk about brokerage relationships. We are going to go in an in-depth review. And so this is going to start off with a lesson. So we're going to do a lesson. We're going to go over the topics that are inside of this section. And then we will review some of the questions and the explanations to some of the questions I actually think that you might see on your exam. So to kick this thing off, I think what's important to understand is the statute of frauds, right? Because that pretty much lays the foundation for a lot of the things that we do inside the state of Colorado. Remember, you're an associate broker. You're going to go through 168 hours. You're going to get your Rec 33, and that Rec 33 is going to give you permission to go take your PSI exam. And once you pass, you get affiliated with a brokerage. So, with that being said, let's talk about the statute of frauds. The statute of frauds, everyone, is this says contracts must be in writing to be enforceable. All right. So when we talk about this is your CBS, your contract to buy and sell. It's whenever we're transferring real estate. Also, on your exam, I think you might see one of these questions where they're like, which contract doesn't need to be in writing to be enforceable? And your answer is going to be a lease for less than 1 year. So, not part of this topic, but I do think that it's important when we're talking about the statute of frauds to know that answer. So, statute of frauds, anything that we're doing must be in writing to be enforceable, which leads us to Rule F because of Conway Bogue, right? So, we had the court case Conway Bogue, and Conway Bogue gave all of us permission to practice some form of limited law. And what that looks like is we are allowed to do fill in the blank contracts as long as we are associated with the transaction. So, Rule F, what does it cover? Listing contracts, buyer rep agreements, the contract to buy and sell. There's addendas, there's disclosures, your change of status forms, counter proposals. All of these are covered by Rule F. So, as a Colorado real estate agent, an associate broker, you must use approved forms when they're available. So, pretty much everything that you're going to touch inside of the state of Colorado has a form that is associated with it, right? When we're talking about helping someone buy and or sell 123 Main Street, well, that's just a typical contract. And so the state, the Colorado Real Estate Commission, has created a contract for us to use when we are looking at this. You cannot alter the language of these forms unless you're adding into the pre-prepared blanks, right? We have the ability to fill in the blank contracts, or if there's an attorney drafted addenda, like we can drop one of those in as well. What you can do versus what you can't do. So what you can't do is draft your own contracts from scratch unless you're an attorney. So if you're an attorney, you can pretty much do whatever you would like. If you are not an attorney, fill in the blank contracts, Rule F. Also, you cannot make changes to pre-printed form language, right? You cannot go through and redline anything. As we're going in, we're doing these things. There's only one exception. And I hesitate to say exception, but it's when there's a section of the contract that isn't going to be pertinent to the contract. And what I mean by that is like when we're looking at contracts with seller financing. Seller financing is not attached to most contracts, right? I would say that the good majority of all contracts that you are going to be handling as a licensed real estate agent in Colorado is not going to have seller financing attached to it. So there's a section in the contract to buy and sell that talks about seller financing. Well, there's a checkbox. Once you check that checkbox, it omits that section. And what happens is when you print off the contract to share to your client, it actually says omitted as in applicable. All right. So that's going to be like really the only time when you have the ability to kind of change some language. And by change the language, I mean you can remove it. So that was the preemptive into this. Let's dive into it now. And let's kick this thing off with brokerage relationship disclosures. So on the far right, you guys can actually see this is a contract. Like this is the disclosure from the Colorado Real Estate Commission. You can see at the very top, it has a disclaimer. The printed portion of this form, except differentiated editions, have been approved by the Colorado Real Estate Commission. Rule F. Guys, there it is. There is the Rule F disclosure right at the very top. So your consumer knows that this is a pre printed legal form. What you can also see at the very top is it says different brokerage relationships are available, which includes seller agency, buyer agency, or transaction brokerage. So let's talk about this. This is a mandatory written form that informs customers about the nature of brokerage relationships. Colorado law does mandate that brokers disclose their relationship status to customers in writing before engaging in confidential discussions. All right. So when we talk about these confidential discussions, I think this is important, right? So if you get a test question and it's talking about brokerage relationship disclosure, when must you disclose your agency with your client to a customer? It's before they give you anything that would be deemed confidential, right? Or motivating. So if they say that, hey, you know what, I'm about to be kicked out of my house because the landlord is selling and I need to buy a house or else I'm going to be on the streets. Well, before they are able to get that information out, you need to pump the brakes. Whoa, whoa, whoa. Anything you say will be used against you for the benefit of my client, right? I represent the seller, right? Because this is kind of where we get into this implied agency piece, right? Where you get into hot water. If you were to have agency with the seller, buyer comes in, buyer starts giving you all these motivations and confidential information, and you're just accepting it. Well, that's implied agency. And in the state of Colorado, we know that we do not have dual agency. Dual agency is illegal in Colorado. And so you would be breaking the law. And on top of breaking the law, like you're going to get sued, right? You're going to get sued probably by that buyer, especially if they feel like you took advantage of them. There's going to be an E&O insurance claim. You could lose your license. Like there's going to be a lot of bad stuff. So when do you use this form? Well, at the first physical meeting or before any confidential information is exchanged, right? So you're going to go through, and if they're just asking basic questions, you don't need to hand over this form, right? And what I mean by that is they're like, so how many bedrooms? Well, there's 3. How many bathrooms? 2. Square feet, 2,000 square feet, right? Like none of that is motivation or confidential information. So that's just real small talk, and you can move forward with that. So the definitions of working relationship form is not a disclosure. All right. This form is only required when a party inquires about a brokerage relationship that is not offered. Remember, we don't have dual agency in Colorado. So if someone's going through and they want you to represent them, you have to let them know, hey, I represent the seller. What this does is it ensures transparency and informed consent from clients. Let's look at this. Let's look at what a transaction broker is. So on your right-hand side, again, let's start it off. You can see that this form has been approved by the Colorado Real Estate Commission. This is a binding contract. Also, what we know is that we need to let everyone know that they should seek tax and or legal counsel. And look, the disclaimer is there in the top. We also know compensation is not charged or set by the brokerage firm. And different brokerage relationships are available, which includes buyer agency, seller agency, or transaction brokerage. Guys, we're looking at this, right? This whole top piece of this section that we are looking at, I can almost guarantee that like everything we just looked at is going to be a test question. Everything on the top, right? Because when we look at what the test is around, the test in the state of Colorado is to protect the consumer. Well, inside of the state of Colorado with our Colorado Real Estate Commission and our forms committee, They make sure that we're doing everything that has maybe happened to a client or got an agent into hot water. They're just going through and they're making sure that this is all very, very transparent. So I'm maybe screenshotting this and saying like, or writing it down and saying, hey, like these are definitely going to be test questions. So at the very top, I do want to point this out. It says exclusive right to buy. So this is an agency agreement, right? This is your exclusive right. And so you can see there's actually two check boxes. There's buyer agency and there's transaction brokerage. All right. So when we're looking at this, your definition of a transaction broker is you are a neutral party where you can assist both parties without advocating for either. All right. So I think this is where there's some confusion when we're like, well, this sounds like dual agency. No, dual agency, you are an advocate, you are a fiduciary. In this, you're just a functionary, right? Like you are a paper pusher, you are Switzerland, you are a referee, you are pushing the paper, you are working for the transaction to get across the finish line. You are not an advocate for anyone. What are your duties then? Well, you're going to present all offers and counteroffers. You're going to assist in the closing process. And obviously, you're going to disclose any known adverse material facts. All right. So anything that does not give the other party a leg up, including where we're going to go through and we're going to let them know material benefits or material defects. So when we're looking at this transaction brokerage, default without written agreement. So in the state of Colorado, if you do not have a signed agency agreement, by default, you are a transaction broker. So let's play this thing out. So what does this look like in the real world? So let's say you guys find a buyer. Congrats. You guys all passed the exam. Now you have a buyer. And they want you to go show them a property and you do not have a signed agency agreement in place. You have no paperwork. Well, congratulations. You are tour guide Barbie. You can go through, you can turn some keys, you can show the house, right? You're living your own HGTV TV show right now. But the moment that they ask you, hey, do you think that this house is worth the price? Or what do you think? You can't give any advice. You cannot give any material benefit. You can talk about the material defects, right? Because that's just a part of the job. But you cannot give any material benefits or advice. So being a transaction broker for a family member, friend, longtime business partner, or co-owner of a property presents a real risk of conflict of interest in addition to perceived conflicts. So what I would say is if you get a test question and it's around transaction brokerage and it's for someone that is in your immediate family or someone that you have a close relationship with, no, you cannot be a transaction broker for that person. You have to be an agent, including yourself. All right. You cannot represent yourself as a transaction broker because here's the thing. You want yourself to win. All right. There's no world where you're like, you know what? It doesn't matter if me or the other party wins in this. No, you care about yourself the most. And that's perfectly human. You cannot represent yourself as a transaction broker. So what's designated brokerage? So again, if we look at this, this is right on the exclusive right to sell or exclusive right to buy. All right. So this is still in our agency agreement. And we can see the agreement and it says the seller and brokerage firm enter in this exclusive irrevocable contract and agree to its provisions. Broker on behalf of the brokerage firm agrees to provide brokerage services to the seller. Seller agrees to pay brokerage firm as set forth in the seller listing contract. Okay, cool. So what this is saying is this is a relationship between who? Well, the seller and the brokerage firm. All right. I think that's important to know as well for your exam is that the agreement is not between you, the agent, and the client. It's between the client and the brokerage firm. The second thing that we look at is it says multiple person firm. If this box is checked, the broker is the individual designated by brokerage firm to serve as the broker of the seller and perform the services for the seller required by the seller listing contract. If more than one individual is so designated, the references in the seller listing contract to brokerage firm include all persons so designated. It also goes one step further. It says the brokerage relationship exists only with the broker and does not extend to the employing broker, brokerage firm, or any other brokers employed or engaged by the brokerage firm who are also not designated. Okay, cool. So we're looking through this and I see some test questions, right? Outside of designated brokerage, I see some test questions. And firstly, right, we just talked about it that the brokerage firm has the agency agreement, not you. The second piece is the brokerage designated you. That's what we're going to talk about on this slide. But the third piece is the brokerage relationship does not extend to anybody else in your brokerage, just you. So, what this means is this. Let's talk about dual agency for a hot second. We know that dual agency is illegal in Colorado. Well, what's not illegal is for you in the brokerage to represent a party and somebody else in the brokerage to represent the other party, both as agents. Perfectly legal. So much so to where your managing broker who's supervising you could also represent the other party. And that would be perfectly legal. All right. So this agency agreement, this exclusive right employment agreement does not extend to anybody else in your brokerage, just you. All right. So what's the definition? This occurs when we're talking about a designated brokerage. This occurs when a brokerage firm assigns a broker to represent the buyer or seller in a transaction. The purpose is to maintain your client advocacy while avoiding conflicts of interest within the same firm. All right. So when we're looking at this thing, each designated broker owes full fiduciary duties to their respective client. All right. And if we were to look at this, this is what I really wanted to point out as we're going through and we're looking at these different pieces. Two brokers from the same firm representing opposing sides in a transaction, each can advocate for their client's best interest. Again, I think this could be a test question, and it's perfectly legal. It does not create dual agency. So, what's single agency then, right? We've been talking about this. Here's your exclusive right. We're looking at it. And this is where the broker represents either the buyer or the seller exclusively. All right. You are representing one party or the other. And when we think about this, we need to think of our acronym COLD AC. We have confidentiality, obedience, loyalty, disclosure, accounting, and care. All right. So this is your single agency. Like you're going through, you are putting your client's interest above your own. You are following lawful instruction. You want them to win. Even if you are going to make less money doing it. All right. I actually think that's going to be a test question on your exam, right? When there's two properties, they both kind of fit the client's need, but one's just a little bit better. And that little bit better one doesn't pay as much. But you know that the one that doesn't pay as much is probably going to fit your client's needs the best. What should you do? Well, we're probably going to tell them about both properties, but yet we're making sure that we absolutely show them the property that fits their criteria the best, even though we're not going to make as much money. All right. This is required in written form, right? When we're talking about the statute of frauds, to have an agency relationship, it must be in writing. All right. So looking through this again, this is your exclusive right. For the most part in the state of Colorado, Guys, these are the contracts we use. We use exclusive rights. We don't have exclusive agencies that we're running around with in the state of Colorado. Now, that's going to be the difference between the two exams. The state exam, which is the second exam that you take on the PSI test, is going to be Colorado specific. And we deal in exclusive rights, not exclusive agencies. All right. Now, let's talk about change of status. This isn't necessarily in this section, but yet I thought it was important. I thought it was important to kind of take a look over this just to get an idea of it. So I have put the change of status form up. You can see again, Colorado real estate approved form. It says this form is to be used at the time a broker changes the brokerage relationship from an agency relationship to a transaction broker relationship. And it goes through and it says, well, hey, this is where we could also mean seller. Seller could also mean landlord. It says this form discloses to the seller and buyer the change in brokerage relationship from an agency relationship to a transaction brokerage relationship. This change is effective only for the transaction between the seller and buyer for the property described below and does not change the relationship with the broker for other transactions. Okay, cool. So what are we looking at? What we're looking at here is we have agency. We have an agency agreement. And yet the stars have aligned, and I have an agency with a seller. I have an agency with a buyer, two separate agencies. I had the listing. The listing was doing the listings thing. My buyer and I were looking at other properties, but then my buyer said, hey, I noticed that you had a listing over at 123 Main Street, and I want to go take a look at it. Okay, cool. So we go look at the property. They said, you know what? I love this house. So much so that I want to put an offer in. All right, let's pump the brakes real quick. We have agency. We know in the state of Colorado, dual agency is illegal. We cannot go through and have an agency relationship with both parties. So what we do is we do a change of status. This change of status takes us from an agency relationship with the seller and an agency relationship with the buyer down to a transaction brokerage relationship with both. All right, so we were up here, agency for both seller and buyer. And then we do a change of status when they say, you know what, let's put this deal together. And we go down to a transaction broker. All right, so this is a commission approved form. It's when we're assisting both the seller and the buyer. You give this no later than when the contract is being signed, the contract to buy and sell, that is. All right. So they need to be signing this at the earliest convenience when they decide that they want to put this deal together. Now, check this out. Let's say the deal falls apart. Deals do fall apart. So we go through the inspection process and they're not coming together, right? We know that the seller does not need to fix anything that is wrong in the home. All homes in Colorado are sold as is, where is, with all faults. All right, I actually do think that's going to be a test question to where they say that there is a inspection. In the inspection, there are some issues. Seller doesn't want to fix it. What has to happen? Well, if we're inside of our contingency period, then the buyer would get their earnest money back if they were to terminate and walk away. The seller is not obligated to fix anything. So let's say we get to that point. The buyer and the seller, they do not come together at inspection and they want to break up. They want to tear this agreement up. Well, do you stay transaction broker for both of them when this agreement ends? When the contract to buy and sell is over, we've ripped it up, we're moving forward? No. You go back to an agency relationship for the seller You go back to an agency relationship with the buyer. All right. So this form has to be given as we're going through and getting the contract signed. And if the contract falls apart, and contracts do fall apart, what will happen is we would go back to our agency status with both parties. All right, let's shift gears. All right, so everyone, let's be looking at our screens now, and this is what we're going to do. I got some questions here. In these questions, they are going to be around these topics. So what I'm going to do is I'm going to pull them up. I'm going to give you a couple seconds to look at it. Then I'm going to give you the explanation to why the answer is the answer. All right, let's jump into this. Upon receiving a call from a prospective buyer who is interested in one of her listings, the broker must present the buyer with a disclosure upon first physical contact, must have the disclosure form signed at the first physical contact, may accept confidential information until physical contact, then present the disclosure form, may orally disclose her representation. All right, so the answer is D, may orally disclose her representation. So as we're looking at this, a broker must disclose brokerage relationships before receiving any confidential information. If there is no physical meeting, the disclosure can be made orally first, then followed by written disclosure. The buyer is not required to sign the disclosure form. All right. So a lot of pieces here. The client, the customer, the consumer does not need to sign this form. You must present it to them. But also, we're talking about the phone call here, right? This is a phone call. And so you're going to disclose it orally. And then if confidential information is coming out, then we're going to present the paperwork. A broker who has become a transaction broker to double end the sale of her listing must have written permission from both parties, may disclose the seller's motivation for selling, may disclose that the buyer will pay more than the list price, must use a change of status form to notify all parties no later than the title deadline. Well, as we look at this thing, the answer is A, must have written permission from both parties. When switching from agent to transaction broker, the broker must use the commission approved change of status form provided before or at the time the offer is written, not as late as the title deadline. They cannot disclose confidential information like price, terms, or motivations when in this representation role. A broker acting as an advocate has which form of representation? Designated broker, transaction broker, facilitator, agent. The answer is D, agent. An agent owes fiduciary duties, including loyalty and obedience, which allows them to act as an advocate for their client. A designated broker is a legal construct based on office policy and can either be an agent or transaction broker. Transaction brokers and facilitators must remain neutral. The first step a broker must take to change from an agent to a transaction broker to double end the deal is to disclose at the end of the contract to buy and sell, have permission in writing from the buyer and the seller he represents, be a designated broker, use a change of status form. All right. The answer here is B. Have permission in writing from the buyer and the seller he represents. Before changing roles, the broker must first obtain written permission from both parties, typically through the listing and buyer agency agreements. All right. So there's a checkbox in there. There is literally a checkbox. And if it's not checked, it means that you can go from an agent to a TB, right? Remember, if it's for someone that I have a relationship with, like my spouse, maybe myself, my best friend from high school, I'm probably going to have to check that box that says seller agency only because I want them to win probably more than anybody else. The change of status form is simply a disclosure, not permission. Disclosure alone is not enough. It must follow prior written agreement. In order for a broker to be a single agent in Colorado, there must be a signed written agreement, verbal consent by the principal to proceed, a retainer fee paid for services rendered, an agreed upon termination date. A signed written agreement. In Colorado, a broker can only act as a single agent for the buyer or seller with a written and signed agreement. While the agreement must include a termination date, that alone doesn't create agency. Verbal consent is not legally sufficient, and retainer fees are optional, not required. A designated listing broker who is representing her seller as a transaction broker may disclose to the seller that the buyer may not qualify, advocate for a better offer, negotiate for the seller as part of the offer process, sign the offer in place of the seller. Disclose to the seller that the buyer may not qualify. Material facts, such as buyer's inability to qualify for financing, must be disclosed, even by a neutral transaction broker. Advocating or negotiating on behalf of a party is reserved for agents, not transaction brokers. Signing for the seller would require legal authority like POA, power of attorney. A team of agents representing a seller as an agent have also found a buyer who wants their representation in purchasing this property. The team of agents will need to change status to a transaction broker, may represent them as an agent since they are a team of brokers, is not allowed to double end a transaction, cannot represent the buyer. They will need to change status to a transaction broker. All right. In Colorado, dual agency is not permitted. A team is considered a single agent, not separate brokers. To represent both parties in the same transaction, the team must switch to a transaction broker status with proper disclosure. They could also keep agency with one party and treat the other as a customer, but they cannot be an agent for both sides.